Chapter 1. Legal Framework Governing Life Insurance. Insurance agents play an essential role in the insurance market. On a daily basis, agents need to be familiar with the legal aspects of insurance. These include insurance products and their specific features, the general form and content of insurance contracts, specific limitations as to the capacity of certain persons to enter into valid insurance contracts, and other important legal limitations. The following chapter provides an overview of the legal framework applicable to insurance and serves as a guide for insurance agents as it relates to the conduct of their professional practice. Insurance agents are not expected to be legal experts in the field of insurance law. However, they can only benefit by being aware of the legal framework and of certain legal technicalities regulating the insurance industry and hence their professional conduct. In Canada, insurance law is taken from several sources, particularly the Canadian Constitution, common law, and legislation and regulation. The Canadian Constitution takes precedence over all other sources of law, including federal, provincial, and territorial legislation. That means that legislation and regulation enacted in the Parliament of Canada and the Parliament of every province and territory must comply with it. Notably, the Canadian Constitution regulates the division of legislative powers between the federal and provincial governments under the Constitution Act 1867. The repatriation of the Canadian Constitution from the United Kingdom occurred with the passing of the Constitution Act 1982, which contains the Canadian Charter of Rights and Freedoms. The Canadian Constitution gives both the federal and provincial governments the power to pass legislation affecting areas or topics under their jurisdiction. Insurance law is considered to be an exclusive provincial matter under the Canadian Constitution. Common law, which originates from England, is law developed by courts based on the decisions of judges, case law, as opposed to statute law, a civil law system based on laws adopted through the legislative process of a state or regulations issued by the executive branch of government of a state. Common law applies everywhere in Canada except in Quebec, where a system of civil law based on the Civil Code of Quebec is enforced. In the common law system, when a statute is passed into law and declared in force, some element of pre-existing common law changes as required to avoid any inconsistency. More specifically, the principles applicable to contracts, civil fault, property, common law trusts and agency are still mostly governed by common law in Canada. In contrast, insurance law has been mostly enacted through legislation passed by provincial and territorial legislatures. This chapter presents an overview of the most important common law rules, statutes, and regulations applicable or relevant to a life and health insurance agent's business, life insurance, and accident and sickness insurance. 1.1. Life and accident and sickness insurance in its legal context. An insurance contract is an undertaking by one person to indemnify another person against loss or liability for loss in respect of a certain risk or peril to which the object of the insurance may be exposed, or to pay a sum of money or other thing of value upon the happening of a certain event, and includes life insurance. Annuity contracts issued by insurers are considered life insurance contracts under provincial and territorial legislation. Life insurance. Life insurance covers the risk of one or more persons dying. Accident and sickness insurance. Accident and sickness insurance may cover loss of health in several ways. Loss due to accident or sickness, or the ability to work at gainful employment, disability insurance. The onset of a diagnosed illness covered by the contract, such as cancer, heart attack, or stroke, critical illness. Accidental death, accidental dismemberment, reimbursement of medical fees and drugs, and long-term care needs. Insurers. Insurance contracts are created and underwritten by business corporations or mutual insurance corporations which are licensed by the government to act as insurers. Agency relationship. In law, a relationship of delegated authority is called agency, and the individuals in that role are called agents. The person or corporation delegating the authority is called the principal. The principal controls the extent of the delegation. Agents. In common law provinces and territories, the relationship between the insurance company and a life insurance agent who sells that company's policies is considered to be that of a principal and agent. In other words, agents act on behalf of the insurance company in selling insurance to clients. The terms and limitations of the agent's authority are outlined in the written contract each agent signs with each company he represents. Insurance agents are either employed by individual insurers or are independent representatives of specific insurance companies to sell that company's products to clients. Agents can be categorized as independent agents or captive agents. First, independent agents. Independent agents will have contracts with 2 or more insurers. Independent agents can sell policies from a number of insurance companies. They generally place their business through managing general agents or MGAs who review applications, submit them to the insurers, collect and allocate commissions. Captive agents represent a single insurer. The captive agent is an employee of a specific insurance company or affiliate of such company and only sells that company's products in return for commission. A captive agent may also be a self-employed worker, having concluded a distribution agreement with an insurer or an insurer's affiliate with an exclusivity clause. Managing General Agent, MGA. A managing general agent, MGA, facilitates business between agents, their clients, and insurers by providing some or all of the following services: supporting and assisting an agent in obtaining contracts with insurers, which can include granting authority to an agent to act on behalf of an insurer; processing and tracking agents' business submitted by an agent; providing agents with direct sales support; facilitating the two-way flow of information between the insurer and the agent; the pooling of commission payments for the agent from various insurers; facilitating the submission of completed contracting requirements between an agent and an insurer; training agents; providing market conduct compliance supports to insurers; and developing products and/or assisting in the adjusting of claims on behalf of an insurer. Agency. An insurance agency is either a corporation or a partnership that holds a license from a regulator or several regulators. An insurance agency must have at least one licensed insurance agent for the same category of insurance for which the insurance agency holds a license. An agent who wants to expand his business by hiring, training, and supervising other agents must apply for a license as a corporate agency life license, meeting the requirements of the specific province or territory where they intend to operate. A corporate life insurance agency can also submit their business through MGAs. There are a number of conditions regarding certain matters such as nominees, designated representatives, the agency name, trade name, and registration with the government that a corporate agency must meet to become licensed as a life insurance agency. Any employee of an agency, whether the agency is a corporation or a partnership, who acts as a life insurance agent will need to be licensed. This includes anyone who solicits insurance, obtains or takes an application for insurance, negotiates for or procures insurance, transmits insurance applications and/or policies, offers or assumes to act in the negotiation of insurance, negotiates insurance continuance or renewal, collects or receives a premium, or develops an illustration for life insurance. An insurance agency must be licensed in British Columbia, Alberta, Saskatchewan, Ontario, Nova Scotia, and Newfoundland and Labrador. Regulation of insurance and licensing. Given the importance of insurance products to clients and society, it's not surprising that all companies selling life insurance policies in Canada, as well as the various distribution channels and the agents themselves, are heavily regulated and supervised. Provincial and territorial insurance acts contain extensive provisions governing insurers. Provincial and territorial insurance legislation gives designated actuaries extensive powers and responsibilities, including reporting on the financial soundness of a life insurer's business operations. Designated actuaries must belong to the Canadian Institute of Actuaries, and they must conform to its practices and processes. Under the provisions of provincial and territorial law, insurance agents must be licensed. The name of the applicable regulatory and statutory framework varies from province to province. The regulation and supervision of life insurance agents will be covered in more detail in Chapter 4, Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents.